have a legal right to challenge the denial or termination of my long-term care benefits? Absolutely. You bought that long-term care insurance policy so that you wouldn't be a burden on your family or friends if you became unable to care for yourself because of physical issues, cognitive impairment, or both. Now, long-term care insurance companies are happy to collect the premium dollar. They're equally happy to rule that you are a family member, don't need those benefits, or you don't need those benefits in the future. They're very creative in finding ways to deny claims, and they hope that you will go away so that they don't have to continue to pay those benefits. They'd rather have you face financial disaster than to see their bottom line profits decrease. You have a legal right to challenge the denial of your claim for benefits, a reduction in the benefits that they're willing to pay, or an improper cancellation of the policy or plan. You also have the legal right to sue for violations of the policy or the laws of your state. So what are those common reasons for denial or termination of long-term care benefits? They've got lots of denial or termination tools in their toolbox. They will often deny claims on the basis that you're still able to perform activities of daily living without the need for substantial assistance or substantial supervision. While you may need assistance or supervision, you don't need that for the right number of activities of daily living. The services recommended in the plan of care aren't covered under your policy. You haven't met the elimination period before the carrier is obligated to provide you with benefits. Or your physical or cognitive impairments aren't so severe that you need assistance or supervision. The facility you've moved into isn't covered by your policy or plan. The caregiver isn't properly credentialed or licensed, or your condition is improved so you no longer need assistance. These are just some of the many reasons that carriers or plans will raise in an attempt to justify the termination or denial of benefits. Now, what are your legal rights? Let's get out that long-term care policy and read it cover to cover, because it will explain what your legal rights and responsibilities are in the case of denial or termination. You most likely will have to file an appeal of denial within 30 to 60 days, or you can lose your right to file that lawsuit. It's really important that you request a copy of the claims file so you can determine the basis upon which the claim was denied or terminated. And there are lots of smoking guns that one can find in a claims file. They need to be addressed in the appeal letter. At my law firm, we know how long-term care insurance carriers operate, and we fight for you if your long-term care insurance claim is denied or terminated. It's not uncommon for policyholders or plan beneficiaries' children or spouses to look for assistance in fighting for the long-term care benefits their loved ones deserve. Now, they often know that you can be frail or cognitively impaired and may not be able to stand up for yourself. Don't delay. Call us at 727-894-3188 to learn how we can help you and your family get the long-term care benefits you deserve.